It came on and then it stopped.
Hello, everyone. Just making sure that the video is coming through. Give me videos in. Okay. Okay. Welcome to the next Facebook Friday. It's November 15th, 2019. I'm immigration attorney Kevin Slattery, located in Tampa, Florida. This is my paralegal Arlene. She is here in case anyone has Spanish language questions. What's that?
It's good.
Okay. So today we're going to talk about, and if you have any questions or comments, you can put them in the comment feed, or you can try and message me directly through the Messenger app. Please try to refrain from posting case-specific questions specific to your facts. You want to keep your privacy, and for any really detailed questions, perhaps schedule a consultation with either myself or any other immigration attorney out there. I would also like to say that anything I say today is not to be construed as giving legal advice, nor does it develop an attorney-client relationship with anyone out there. If you'd like to talk about case specifics, give my office a call, and we can talk in privacy. For anyone who's not local to the Tampa Bay area where I am located, I can do consultations via Skype or telephonically. I'd also like to say that with the holiday season coming up, we're going to try and do a discount on consultations if people want to bring canned goods that we'll donate on your behalf to local food banks or charities. I'll discount my regular consultation fee by half if you could bring at least 10 canned goods. That'll be valid through November 30th. And if you're out of town and not able to come in physically, I'll take your word for it that if you just promise to make a donation of some canned goods to a local food bank here in the holidays. So that consultation discount will go on through November 30th. Moving on to fiance visas. We're going to talk about that, and if I can squeeze in some talk about deportation at the end, we'll talk about that as well. Just generally going to go over the process, what's involved, what are some pitfalls, things you want to watch out for. Maybe the advantage of doing a fiance, if you're not already married, the advantage of doing a fiance case versus one where you maybe are planning on getting married abroad. Maybe holding off on that and doing a fiance visa instead. So the fiance visa, it's a process whereby you're seeking to bring in the U.S. citizen, and it requires the petitioner to be a U.S. citizen, trying to bring in your foreign fiance to get married here in the United States and conclude the process here in the United States. Are you getting posts? Do you see that? Maybe it's people joining. Yeah. Basic requirements. So it's a three-step process. The first step is with the Immigration Service, known as U.S. Citizenship and Immigration Services, USCIS. The petition gets filed with that agency by the U.S. citizen. Both yourself, the U.S. citizen, and your foreign national fiance both have to express an intent to get married within 90 days of coming into the United States on that fiance visa. Thus, the popular show 90 Day Fiance, which I think Arlene's a fan of.
Yes, I am.
So you must have that intent to marry within 90 days of entry. In order to file the petition with the Immigration Service, you and the foreign national fiance must have physically met each other at least one time in the 2-year period just prior to filing the petition with the Immigration Service. You can get that. It's possible to get that 2-year, physical presence, physical meeting requirement waived if you could demonstrate, for example, that it was against social or cultural norms in your home country. In some countries you might have, for religious reasons, arranged marriages where you wouldn't necessarily meet the fiance until actually the date of the marriage. So for social or cultural reasons, it could be waived. It could also be waived if it might pose an extreme hardship on the U.S. citizen petitioner. For example, maybe somebody has a debilitating disease that makes it very, very impractical and difficult to travel abroad to go see your foreign national fiance in person. For reasons like that, it might also be waived. But generally speaking, you must have been in the physical, physical proximity to your fiance within 2 years prior to filing. Assuming that you meet those basic requirements, some other things that they're looking at, normally we always think about the criminal history of the foreign national and how that might pose an obstacle to immigrating, and that's true. But in the context of fiancé cases, the Immigration Service is also screening the criminal history of the U.S. citizen petitioner. So generally speaking, they're looking for violent crimes, violent criminal history. Let's see here. So violent criminal history, and that information will be disclosed, even if the petition is approved, that information will be disclosed to the foreign national fiance by the embassy officer at the visa interview. So if you are afraid of that, just be aware that's something that's going to have to happen. Criminal history that pertains to certain offenses against minor children, typically of a sexual nature, but certain offenses against minor U.S. citizen, a minor doesn't have to be a U.S. citizen child, minor children, that can pose a problem in terms of implicating provisions of what is known as the Adam Walsh Act. There is a that can be waived, so it can create problems. It can be a basis for the Immigration Service to actually deny the petition, notwithstanding the fact that you meet all the other requirements. And what they're looking at is whether you pose a risk to that foreign national fiance, and sometimes the derivative children, I suppose, that you're hoping to also bring along on derivative visas, K2 visas. I'll get into that in a second. Just to put it out there, I generally don't take Adam Walsh Act cases. It's just something I generally don't want to do. I guess I would have to look at the specific facts of your case, but as a general matter, I don't normally take those. But there are attorneys out there who could, look into that for you. So if you have that sort of issue in your background, please note that that could be an obstacle. As far as the Adam Walsh Act, again, a no-risk determination assessment would need to be done by the Immigration Service. You'll want to prepare a very thorough package if that's your issue, because those are complicated cases. They're also looking at how you met. There are rules that must have been followed if you met through an international marriage broker. If you go onto the Immigration Service website, you can find information about that. But generally speaking, they want to make sure that if you have used an international marriage broker, that you followed the law in that way. Information has to be disclosed to the foreign national about you, your criminal history, things like that. If the entity through whom you met, there's a lot of dating websites out there, if for example, a dating website is not necessarily tailored to putting foreign nationals together, a U.S. citizen with somebody abroad, if that's not their primary purpose, so if you have just a general dating website that doesn't discriminate between trying to pair people up who are U.S. citizen and U.S. citizen and U.S. citizen and foreign national, they're probably not going to fall within the parameters of being an international marriage broker. But if you think that how you met, the entity through whom you met might qualify as an international marriage broker, you're going to want to make sure that the rules were followed, and that's something that an attorney could help you evaluate if you went in and talked with an attorney and described how you met. Let's see, derivative children. So I mentioned before that children might be able to come stepchildren to the U.S., potential stepchildren, future stepchildren to the U.S. citizen. So unmarried minor children, meaning under the age of 21, can accompany their parent who is being sponsored for the K1 fiancé visa on a K2 dependent visa. It can be a good avenue for those children, and this comes into play as to whether or not one would want to pursue a K-1 visa for their foreign national fiance versus, let's say, going to that fiance's home country, getting married there, and instead filing a family petition. As strange as this sounds, a U.S. citizen step-parent cannot file a petition, I'm talking about a family petition, a petition for relative, cannot file a family petition for a stepchild where the step relationship was created after the child's 18th birthday. So if U.S. citizen marries fiance in the home country, and when they did that, the foreign fiance's children were 19, 20 years old, one, it can't come on a K-2 derivative visa, because if there's a marriage, they're no longer fiancé, so you wouldn't be doing a K-1 case. You would be doing the regular type, which is a petition for relative followed by an immigrant visa with the embassy. And the way the law is written, the step-parent could not file, because the marriage happened when the children were over 18, could not file separate I-130 petitions for the stepchildren. In that scenario, the primary beneficiary would have to come in, get their green card, turn around and file petitions for those, older children back home, and there's backlogs and it could take a long time. But in the fiance process, the law is actually worded such that minor, under 21, unmarried children of the K-1 can come in on K-2 visas, and then when the K-1 parent marries the U.S. citizen petitioner and goes to file an adjustment of status application, so too can those K-2 children, notwithstanding the fact that they were over 18 when mom or dad married the U.S. citizen. There's also case law that says the child could have turned over the age of 21, later after they came in. So at the time of filing their adjustment of status application, they're now over 21. What is important is that they were under 21 when they came in. So that's a good way where you're trying to keep the family together. Maybe don't go down and have that destination wedding in whatever country it is that you want to go get married at. Perhaps for the sake of being able to bring the children over at the same time, do a fiance-based visa case. So if you're contemplating marriage abroad and then doing the immigration paperwork, and if there's children involved that are over the age of 18 but under 21, go talk with a competent immigration attorney who can discuss those pros and cons with you. As far as the application for so once you've gotten the petition approved by the Immigration Service, that petition will be valid for 4 months. And generally speaking, you hope to get the next step, the K-1 visa, approved by the embassy within the validity period of that underlying approved petition by the Immigration Service. Sometimes just because of processing times abroad, the petition may be reaching the end of its validity period before you would actually be going into the embassy for the actual visa, for the visa interview. The Department of State runs the embassies. They do have the authority to extend the validity of the underlying petition. So if you're right now in the scenario where maybe you don't have a lawyer and your K-1 visa interview at the embassy is not likely to occur until after the underlying petition has expired, don't fret too much. In practice, usually they're pretty good about extending the validity of it so that they can issue the K-1 visa. They don't always, but they can. The embassy is, we talked about before the criminal history of the U.S. citizen and that's impact. Well, they're also going to be evaluating the foreign nationals, what they call admissibility to the United States, looking at things like, does the foreign national have their own criminal history? Do they have their own past negative U.S. immigration history? Have they been previously deported from the United States? Have they maybe not been deported, but have they previously been in the United States and overstayed, or maybe they entered without inspection and were unlawfully present from the very get-go? And did they accumulate too much time and unlawful presence after their 18th birthday? such that when they left the United States, they might have triggered a 10-year bar to reentry. And then the question becomes, well, what's the implications there? Maybe you have an approved fiancé petition, but there are these obstacles, these grounds of inadmissibility in the way to actually getting the visa issued abroad. So the Department of State in their Foreign Affairs Manual has some policy whereby, you know, a K-1 visa is, it's sort of a quasi-immigrant. It's a non-immigrant visa. Non-immigrant visas in general are those for which one does not have the intent to immigrate to the United States to get a green card. A K-1, although thrown into that non-immigrant category, really one does have the intent to immigrate. The purpose is to come in and get married and then do adjustment of status. So for K-1s, they have waivers for non-immigrant visas that are a little bit less, they're more forgiving. The standard for approval is more forgiving than are waivers for some of the grounds of inadmissibility that would affect immigrant visa applicants. So for a K-1, what they're looking at is if they gave you a waiver in the non-immigrant context, and then you came into the United States and got married and then wanted to pursue adjustment of status, would those grounds of inadmissibility be an obstacle in the adjustment of status case? And if they are they so great, are they so serious that there would not be a waiver available for the green card one, for the adjustment of status? So, for example, you may have a false claim to citizenship. That could be approved with on a non-immigrant visa, but generally speaking, there's no waiver available for that for an immigrant visa or an adjustment of status case. So in their policy manual, there's language to the effect that says, hey, embassy officer, see if there's a waiver available for the adjustment of status. And if there is not a waiver available in the adjustment of status context, then don't give them a waiver for purposes of giving them the K-1 visa. So you'll need an attorney, you know, to evaluate, especially if you have negative criminal history or immigration history, evaluate, do you have any grounds of inadmissibility? And if so, are they the type for which there exists a waiver in the green card context? If there is a waiver available in the green card context, then at the fiance visa stage, the embassy officer would likely issue a refusal of the visa, but then give you paperwork that says, but apply for a waiver with the immigration service. And the immigration service can sort of approve that on a conditional basis. Then the officer at the embassy would approve hopefully approve the K-1 visa with a waiver in the non-immigrant context. You come into the United States, you get married, you do your adjustment of status case, and with the conditional approval of the waiver on the green card context, you could then adjust status and become a permanent resident. As far as other issues that could affect your K-1 visa case abroad, depending on the country you come from, we also have to consider the travel ban that's in effect. You know, talk with an attorney. You know, there's a list. You know, Iran, Sudan, I think. Maybe they were taken off the list. There's a list of countries, and that can affect your ability to come in. You know, even if you have a clean case otherwise, the simple fact of the country that you were born in could pose an obstacle to getting the K-1 visa issued. There are waivers available for that as well, but statistics aren't very optimistic in that. Travel ban. Also, other developments that could affect it. So the embassies are always looking for, are you likely to become a public charge in the United States? Basically a financial burden on the United States. So in the summertime, the administration published a final regulation, essentially redefining what a public charge is, making the standard a little bit more loose, and therefore more people would likely be deemed to be likely found to become a public charge in the United States. There are several courts in the United States. There's been litigation on that. That was supposed to go into effect on October 15th. There has been litigation going on. There are injunctions in place right now. So the new definition of public charge is not in effect. Now, that's actually a litigation over the Department of Homeland Security's regulation about it, which would affect adjustment of status applications. The Department of State, which runs the embassy, sort of has a parallel regulation that was issued later in the game. And to my knowledge, there's not yet been litigation filed against that. So technically, there's not an injunction in place against the new definition of public charge as set forth by the Department of State. However, they don't have a form in place to process that. And so they have issued a statement that just says, although their regulation is there, they're not necessarily enforcing it until such time as they create the form that allows them to evaluate that a little bit better when they have an applicant in front of them. I assume there's probably going to be litigation on that as well. So you have to worry about that. And so follow. You can find information about that on the Immigration Service website, or call my office and I can give you more details on that. Maybe I'll do another session on the litigation in place. When somebody is issued the visa, which will be issued for a limited period of time, usually I think 6 months, I can't, six months, one can come into the United States during the validity period of that visa. Once the K-1 visa holder enters the United States, the couple has 90 days to get married. So after you get married, that is, and if you didn't get married within the 90-day period, I'm not advising this, but it's legally possible that you could still do an adjustment of status case through that U.S. citizen petitioner who filed your K-1 case for you, to do instead an I-130 petition for relative followed by an adjustment of status application. If you have children, though, that are between the ages of 19, 18, just turned 18, and 21, I wouldn't necessarily advise that. You want to make sure that you'd be adjusting on the K-1 case so that the kids don't get, they don't drop out of it. But you come in within 90 days. The regulations actually do say that you can apply for work authorization so that you can be work authorized during your 90 days of K-1 status. Practically speaking, though, it's never going to happen. The processing time, so in theory, you can file a paper called an I-765 asking for employment authorization for those 90 days. The problem is USCIS is not adjudicating I-765s in 90 days. It's usually taking them at least 5 months or so. So by the time your 90 days is up, they still won't have made a decision on that. Once you get married within 90 days, you can file an application to adjust status. That is the form, once approved, turns you into a permanent resident. The key is to get married within 90 days. The law does not require you to file your adjustment of status application within 90 days. The key component is getting married within 90 days. So if you got married on day 89 and then filed the application on the 91st day, it would be processed. With the adjustment of status application, there are some technical things. I talked about public charge before. So in connection with any adjustment of status application through family, typically the petitioner has to file an affidavit of support guaranteeing that you're not going to become a public charge. There's a form for that. And the government is looking at primarily, among other things, but primarily is the U.S. citizen's income for his or her household size at least 125% above the federal poverty guideline for that individual's household size. If the individual's income is insufficient, but maybe just close, if he or she has assets, assets can be added to make up the difference. On a spouse case, they'll want to see assets that are equal to an amount that is 3 times the shortfall. So let's say you're short $1,000 on income, but you have at least $3,000 in assets, then those assets could be used to make up the difference. It's not to say that they wouldn't still give you a hard time. I have seen affidavits of support that on their face were sufficient, but the Immigration Service has insisted that they're not, and they'll request a joint sponsor. Sometimes you can fight that and get it through. Sometimes you might want to consider just giving them a joint sponsor's affidavit of support to get it through, although sometimes I think that they're wrong in asking for a joint sponsor. Other things that you can ask for with the adjustment of status application, you can ask for what's called an advanced parole travel document. You can ask for temporary employment authorization. Some field offices around the United States take longer processing times than others, so you would want to be able to work while you're waiting for your green card. Here in Tampa Bay, at least recently, they've been pretty good about getting people into their adjustment of status interviews pretty quickly. And in recent experience, quicker than the National Benefits Center gets around to approving the temporary employment authorization card. I can't say that that's the same across the country. I'm sure there are some USCIS field offices where the processing times are longer, and in those situations, one might get their temporary work authorization before they get their green card. With the temporary work authorization, one can go down and get a Social Security card, Social Security number. Several states may vary in what the DMVs would accept for documentation. Generally speaking, here in Florida, with proof of filing of the case, you can bring certain documents down to the DMV to get a temporary driver's license while you're waiting for the green card case to be approved. What else can I tell you on the adjustment? Oh, the advanced parole. So what I mentioned, the advanced parole previously, that's a travel authorization document. Generally speaking, if one has a pending adjustment of status application, departs the United States without this advanced parole already having been approved, the act of departing will be deemed an abandonment of the adjustment of status application. So all that paperwork you've done, all those fees you've paid to do the fiancé petition, the fiancé visa, and the adjustment, all of that will have been flushed down the toilet if you left the United States while the adjustment was pending without the advanced parole. So very important, if you do have desire to travel internationally while the case is pending, make sure you get that advanced parole in hand. Sometimes there are emergencies that may pop up that demand your travel back to your home country, maybe a death in the family, or a very, very sick close relative who maybe is close to passing away. On a case-by-case basis, if the Immigration Service feels the circumstances warrant it, at the local field office, it's possible for them to issue an emergency advanced parole. You would have to, convince them that's warranted, but that may be possible. So if you're in that situation, and you don't have a lawyer, just keep that in mind and try to do that. And by the way, if anyone has any questions about anything that I've said, please feel free to post comments, write a comment, and I could expound upon what I'm talking about. Conditional permanent resident status. Typically, and again, this goes on processing times, but typically because one has to get married within 90 days, and because I can't imagine any USCIS field office around the country taking longer than 2 years, there is a provision in the law that says when one receives their green card through marriage to a U.S. citizen, if on that day the couple has been married less than 2 years, the foreign national is only going to get a 2-year conditional green card. Later, that individual is going to need to file what is called a petition to remove conditions. This is the Immigration Service's second bite at the apple, so to speak, to make sure that your marriage is a real one, that you did not sneak a fake case by them. It's ideal if everyone is still happy and together. But with the divorce rate being what it is, just, not all marriages work out. It is possible to still get the conditions removed, even if a couple breaks up before it's time to file that next case. The standard is not the viability of a marriage, it's did you enter the marriage in good faith. So that's what they're looking at, and I wouldn't advise anyone to enter into a fake sham marriage just to get an immigration benefit. That carries with it very severe consequences, the inability for anyone else in the future to petition for you, even if that other relationship would have been a real one anyway. Other little technical things too. Although one may have the true intent to marry within 90 days of entry, maybe things happen once you're here, and the person isn't who you thought they were, either party, and the marriage doesn't happen within 90 days and never happens. There are restrictions on K1s and their K2 children who have come in with them to pursuing adjustment of status through, for example, some other marriage. So if somebody came in on a K1, did not marry the K1 petitioner, and later met and overstayed, which I'm not advising. You should leave if you're not going to be marrying the person. But some people have overstayed, didn't marry the petitioner, and may go on to meet somebody else in a good faith relationship, and then they say they want to do another. They want to do a marriage case, and there's generally a restriction on being. You can get married, and that person can file a petition for relative for you. But if you're still here in the United States, you're not going to be able to do an adjustment of status case through that new U.S. citizen that you've married. Typically, and you would want to talk to a lawyer to look for any exceptions that may be out there. But generally speaking, you can't do an adjustment of status case through a subsequent U.S. citizen if your last entry was through the K-1 visa filed by some other U.S. citizen petitioner. Generally speaking, you would need to do a consular processing immigrant visa case. The problem, however, then becomes if you overstayed by more than 6 months or more than a year and then leave, you could trigger a 3 or 10-year bar to coming back. There are waivers for that in that context, and you would want to talk to a lawyer about that. There's what's known as a provisional unlawful presence waiver, and then there's the old-fashioned variety where you've already left before maybe you've asked for a provisional waiver, which is applying for the waiver from abroad. I'm not going to talk too much about that though, because we're just talking about general K-1 fiance visa information now. So that pretty much sums up the K-1 stuff. So if people have questions about that, you can post those, and I'll try to answer those. As far as deportation, there's currently there's how shall I say this in a politically correct way? There's prosecution of deportation cases are going forward. Certainly the government has in their discretion, the choice to not seek one's removal from the United States. In the past, there have been policies where, for those who maybe were here a long time, have been here, no criminal history, U.S. citizen family, they may not have been a priority, and the government's resources would have been more focused on those who, serious immigration violators, serious criminal history, things of that nature. Nowadays, deportation, has sort of been ramped up, notwithstanding a person who doesn't have serious criminal history has been here a long time. So you would want to go talk to an immigration attorney to see. There's been some developments. So if you have been in deportation proceedings before, maybe you have an existing order of removal, go talk to a lawyer. There have been some developments. So some forms of relief, one in particular that comes to mind called cancellation of removal. There are some people who in the past may have been disqualified, been told that they were disqualified from cancellation of removal because they were not, they didn't have, for example, enough time of good moral character. So cancellation of removal for people who are not permanent residents, in a nutshell, says you have to have been here at least 10 years. You can't have certain disqualifying criminal history, that for those 10 years you've been a person of good moral character. Some people, and the clock stops when you're served with a notice to appear. And some people may have been here at 9 years and 11 months, and then they were served the notice to appear, and the clock, under the law, the clock stops. So by the time they go into court, by the time they get a hearing notice, they have been 10 years, here 10 years. But the notice to appear that they were served stops the clock at 9 years and 11 months. So there's been some good case law recently where if you read the statute, it defines what a notice to appear is. And a notice to appear, the definition, essentially includes on it the date and time of your hearing. Well, what the government often does is they will put in that portion of the notice to appear, it'll say your time and date, to be determined, to be determined. So the Supreme Court spoke recently on that. And for the stop time purposes, I mean, attorneys are litigating other issues, but for purposes of that provision that says the clock stops, if your notice to appear lacked the time and date on it and had language like to be set or to be determined, the clock did not stop. Now, there's been a Board of Immigration Appeals case that came out and said a subsequent notice of hearing, one issued by the court that says, okay, your first hearing is on such and such date, that document sort of perfects the notice to appear and stops the clock. Now, attorneys are fighting that and disagree with that, but maybe you only needed to get one more month or a couple more weeks to reach the 10-year mark. If you have a prior deportation order and you go back and look at it and it has language on it that says to be determined or to be set, you should bring a copy of your file to an attorney to evaluate whether there's good cause to try to reopen your case to pursue cancellation of removal. You might have been told back in the deportation case at the time that you weren't eligible for it, but this new case law might actually show that you are eligible for it, that you were eligible for it, which could serve as a good basis to reopen the case. There are lots of different things to explore in deportation cases as far as eligibility for relief. Sometimes procedural defects, maybe you don't have relief per se, but maybe there was Fourth Amendment violation, an illegal search and seizure, maybe the ICE barged into your house, you didn't give them permission to come in and they didn't have a warrant to, and they knocked your door down, that sort of thing. You do have constitutional rights even though you may not have immigration status in the United States. If a Fourth Amendment violation is egregious, that could be a basis to suppress whatever information has been obtained as a result of that Fourth Amendment violation. So know your rights. There are groups out there who put out some. Maybe I'll share them on my Facebook page later. That I've done it before. That just explain what one's rights are here in the United States, and it's good to know those. But as far as forms of relief and deportation. Marriage, what we've sort of been talking about, that sometimes can be relief. Obviously, you wouldn't want to be getting married just to create an avenue of relief. It's because you were in a real good faith marriage, and there is a heightened standard to the Immigration Service approving a petition for relative for one who has gotten married during active removal proceedings. So keep that in mind, and there's an extra little statement that needs to be included. But just because you have a deportation order, particularly if you never had an immigration attorney representing you at the time, perhaps bring your paperwork to an attorney now who can evaluate it for the effect of changing case law over the years. Sometimes a case, a Supreme Court case, may have come about that nullifies, or one would argue nullifies the basis for why you were ordered deported, and could be good reason to go back and reopen the case. Unless people have specific comments or questions that they want to throw out, there's a lot that could be said about deportation, but it's hard to get into all of the nitty-gritty because a lot of it would be specific to fact patterns. But again, look at I can't stress enough the to be determined language on your notice to appear, because that's a possible avenue for relief for many people out there. So unless people have questions, I'll give a few seconds, maybe a minute or two, for people to post questions. Maybe I can give a couple comments on, I don't know, any ideas of things related to deportation or fiancé visas?
If you want to explain a little bit how kind of deportation hearing looks like.
Yeah, I mean, let's talk about the hearing. Yeah. So initially, and it's very important to keep the Immigration Service and ICE and the court updated with your address. The Immigration Service, or whatever entity you've last dealt with, Customs and Border Protection, U.S. Immigration and Customs Enforcement, they're going to send documentation to the last address that you provided. There is available on the USCIS website, which is uscis.gov, a change of address form. Every time somebody moves, you should be updating your address. The court, which is not part of the Immigration Service, the immigration courts are part of the U.S. Department of Justice, which is under the executive branch. They are not part of the judicial branch. The immigration courts are an executive branch, entity. Their ultimate boss is the President of the United States. And their more immediate boss, the Attorney General. So if you get a document from the immigration court and during proceedings you move, and typically the court with any hearing notices will send an address change form that you can use, but very important that you update the court with your address and the Immigration Service. If you miss a court hearing, even if you have relief available in those deportation, those removal proceedings, the judge is likely to order you removed in your absence. He'll give you what's known as he or she will give you what's known as an in absentia removal order. Very important to go to court. A lot of these notice to appears, after that Supreme Court case that I talked about, the ICE officials, the Customs and Border Protection officials, USCIS officials, all entities who can issue notice to appears, sometimes they're putting what most attorneys look at as fake dates. They're not real dates, they're just sort of like placeholder dates, and then you'll sometimes get a hearing notice that that gives you the real court date. It's unfortunate, but go to court even on the date. If it's likely a fake date, go anyway, because you don't want to miss your hearing. The hearing itself, typically your first hearing is going to be called a master hearing. It's a preliminary hearing at which the judge is going to go over the charges against you. If you don't have a lawyer and you're hoping to get one, the government does not provide one for you. It is not like criminal defense here in the United States, where if you can't afford a lawyer, the government provides one to you. Immigration proceedings are civil proceedings. So if you want a lawyer, you have to go find one yourself, and there are some pro bono entities out there. The court typically at your first hearing will give you a list of either some pro bono or low cost legal service providers. There are statistics that demonstrate that those who have attorneys in removal proceedings, there's a higher favorable outcome for those people than those who don't. There are, I'm not going to get too much into this, going along the southern border right now, there's a policy in case with migrant protection protocols. They have some tent courts put up along the border right now. Used primarily for those who are seeking asylum along the southern border. There's concerns by attorneys about access to counsel for those people. But those courts aside, generally you'll go to your master hearing. The judge will go over the charges with you. If you're wanting an attorney, it's recommended that you don't necessarily go over, contest or admit the charges against you. My suggestion would be that you ask the judge for more time to find an attorney. Typically, in my experiences, the judges are pretty good about affording you at least one continuance to go find an attorney. Nowadays, the judges are under pressure by their bosses to complete a certain number of cases within the year, which it could affect, they get performance ratings, and that can affect, their retention there with the immigration courts. So my impression is that they're less inclined to give you another continuance if you show up at your second hearing without a lawyer, if your reason for the continuance in the first place was to find one. So use your time wisely during that continuance to try and find an attorney. When you do go over the charges with the judge, you can admit or deny them. It's the government's burden to prove that you are, in fact, removable. So maybe you are, but maybe the government fails to prove that, in which case the judge could terminate the deportation case. To the extent that you concede to the allegations and concede that you're removable, or the government proves them, then the judge would move on to relief and ask whether you're eligible. He's not necessarily going to do the job for you and tell you what you're eligible for. Some judges may help guide you through that, especially if you don't have a lawyer. But if removability is established, the judge will then ask whether there's any relief available. If there is, you'll indicate that to the judge, and the judge would typically then give you a certain amount of time to file the application for relief, whatever form of relief, like cancellation of removal, that it is you're eligible for. And then he or she will set what's called an individual hearing, which is sort of like the trial, the date on which your application will be thoroughly reviewed. Maybe you get to call witnesses, go over the evidence. Some cases may be harder than others, and your individual hearing may be very long. Some may be short. If you do have, again, probably recommended to talk with a lawyer if you can do so. Especially if your issues are complex, especially if you have criminal history, especially if the form of relief that you're seeking involves a waiver. Those can be difficult. If you lose your deportation case, your removal case, the judge may order you removed, and you can appeal that decision to the Board of Immigration Appeals. There is strict time limits on when you must file your appeal, 30 days. If you lose at the Board of Immigration Appeals level, you could also file for review in a circuit court. Around the country, there are 11 circuit courts. Here in Florida, we're in the 11th Circuit, so you could file for a petition for review of a negative Board of Immigration Appeals decision to the 11th Circuit. And then, of course, you have the Supreme Court. So an order of removal is not necessarily the end of the story if you have some fight in you and if you have a good case. So with that, if anyone has any questions, and if not, I will sign off. And what's that? Yeah.
Si alguien tiene alguna pregunta en español, por favor ponerla en la sección de comentarios y con gusto la puedo traducir al idioma inglés.
And so I don't see any comments posting up, but I just want to remind everyone, again, with the holiday season, until November 30th, if you do want to schedule a consultation with my office, just bring in, maybe at least the more the better, but at least, 10 canned good items, which we'll, pass along to a local food bank for use in the holidays when I know they desperately need it. And I'll discount, if you do that, I'll discount my consultation in half. And for those of you who maybe want to do telephonic or Skype consultations, I'll just, on a good faith basis, tell me that you're donating to your local food banks or charities, and I'll discount my consultation in half. And I appreciate being able to provide this information to all of you out there. And after I disconnect, if you still have any questions about the presentation, just again, feel free to direct message the office through the Facebook page. It was nice talking to everyone, and happy holiday season. Take care.